But getting to the Supreme Court is easier said than done. You'd probably have an easier time making it in Hollywood. This is what you've got to do.
First, buy a bus ticket to LA, then knock on all the agents' doors until one of them agrees to see you, then wow them with your talent and good looks. Oops. Oh, that's how to make it in Hollywood. As far as the Supreme Court is concerned, getting to the Supreme Court involves getting onto the docket. The docket is the list of cases the Supreme Court members have decided to consider.
But getting onto the docket is a battle.
To get onto the Supreme Court docket, you must first submit a brief, which is a document containing the collected legal arguments of your case, and you must include precedents. Precedents are prior judicial decisions that help support your side of the argument.
Parties must wait a long time before their case gets considered for the docket, unless it's an emergency of some sort.
And even after that long wait, chances are the court will end up making the decision of stare decisis.
In Latin, stare decisis means let the decision stand. When a decision stands, the case does not get onto the docket, and it does not get heard in the Supreme Court. The ruling made in the lower court will stand.
If the Supreme Court justices accept your brief, they grant you what is called certiorari. Although it sounds like a monster Godzilla would fight, it's actually a review of the case. Being granted certiorari means that you are now on the docket. Getting this far is pretty impressive in and of itself, even if the court doesn't overturn the case in the end.
4 of the 9 justices must agree to accept a case before they grant a writ of certiorari. If the case gets to the Supreme Court, it may have a chance to shape history.
Remember earlier we mentioned the Supreme Court was once seen as ineffective, meaning it rarely overturned cases? Well, it wasn't until Chief Justice Marshall's court, which lasted from 1801 to 1835, that real authority was placed in the hands of the justices in form of judicial review. Judicial review is the power of the courts to review the decisions of another department or level of government. The court can interpret the constitutionality of the decisions and subsequent actions.
But the court did not get this power from the Constitution. Instead, it just claimed it for their own during the case of Marbury versus Madison, 1803.
Judicial review allows the Supreme Court to decide all final arbitrary questions regarding the U.S. Constitution.
Since Marbury versus Madison, the judicial branch has, at times, determined whether the actions of the President, the Congress, the American bureaucratic system, and the states themselves are indeed constitutional.
Of course, while the judicial branch has the interpretive checking power called judicial review, the other branches have checking authority over the judicial branch.